Hi, my name is Nadav Ravid. I'm the managing partner of Ravid Law Group. Our firm specializes in representing landlords and tenants throughout the country and negotiating their commercial real estate leases. Each month, our firm publishes a DIRT report, which analyzes various cases and laws that have come down throughout the country that impact commercial real estate leases. And this past year, we've spent a lot of time, most of our DIRT reports, analyzing various cases that have come down, analyzing the issues raised by COVID-19, and ultimately trying to answer the question of whether or not the rent is still due despite the pandemic. And early on, we saw a case that was favorable to the tenant, a restaurant tenant that was based out of Chicago, in a bankruptcy proceeding where the landlord, the judge, in essence, ruled that the tenant was not responsible for 100% of the rent, only a portion based on the part of the premises that the tenant was still able to use in order to conduct takeout. A lot of commentators analyzed that case and said, well, that looks like an outlier because it's in a bankruptcy setting. And the conventional wisdom was that the landlord still had the better argument that rent would be due in most cases. There was also a very unique force majeure provision in that Chicago restaurant case, the bankruptcy case. But then we started to see several cases trickle through that were actually very favorable to the landlords. We saw a case, for example, where GAP was, in essence, the preliminary ruling was that they would probably still have to pay their full rent, but the judge gave them a 10% discount. So they still had to pay millions of dollars of rent for space in New York. We also saw another case against Christian Louboutin where the landlord again prevailed and was able to, or the tenant was not able to avoid paying the rent. And then we saw another case where another tenant was ordered to pay rent because the court ruled that, look, you were only prevented from operating for 2 months out of a 10-year lease. This is the last year of the lease. That's not really what was intended to be covered by these legal concepts, these defenses that the tenants were raising of frustration of purpose and doctrine of impossibility and force majeure, et cetera. Well, so the pendulum had swung in the landlord's favor, and we were seeing more and more cases coming down on the landlord side. Now, in the past few months, the pendulum has swung in the other direction, and now we're seeing real cases that are landing in the tenant side. And we've seen several cases. We talked about a case last month where a tenant was, on a preliminary basis, it was ruled that it looks like the tenant could be excused from paying rent under the claim that the pandemic was a casualty. And under the language of the lease, the tenant was permitted to stop paying rent during the time of a casualty. We also saw a few other cases that we talked about that, again, ruled in the tenant's favor. And this month, we want to cover a case that came down that, again, ruled in the tenant's favor, a restaurant tenant out of New York, which basically, on a preliminary basis, ruled that the tenant, I'm sorry, it was not a restaurant, the tenant, it was a cosmetic retailer, was not required to pay rent. I say restaurant because actually there was another case that just came down this week out of Boston, which was very favorable to the tenant. The tenant prevailed on a summary judgment basis, ruling that during the pandemic, at least during the 3 months when there was a government order that required the restaurant to shut down, that the rent was not due, at least just during that period of time. But again, we'll cover the Boston case probably next month, but let's talk about this month's case, which is a New York case where a cosmetic retailer took the position that its lease, they were excused from paying rent because their doctrine of frustration of purpose applied, because here you have a cosmetic retailer where the guests are supposed to come in and try on makeup. And due to the government orders, even when the stores were open, the guests were required to wear masks and, again, keep 6 feet apart, and basically, for the most part, frustrated the main purpose of what the lease was intended to to be for. So the court analyzed the force majeure clause, doctrine of impossibility, frustration of purpose, and ruled that, again, on a preliminary basis, the landlord was not going to be able to prevail on a summary judgment basis. The tenant was going to be permitted the opportunity to present various facts and support for why the tenant should not be required to pay rent, because the purpose of the lease was frustrated. And the court seemed to suggest that it was sympathetic to the tenant's position. And so ultimately the court ruled that at this point in time that the case will need to proceed and give the tenant an opportunity to prove its case of why rent would not be due. But the court did have some interesting quotes, and I want to read a few. When it defined the pandemic, it talked about the fact that the tenant would be able to show that the purpose of why it stopped stopped operating, or stopped being able to pay rent was for a reason never imagined, let alone foreseen by either defendant or plaintiff. In essence, the court focused on the fact that this was not a foreseeable event. That the COVID-19 was really something that the parties were not contemplating when they negotiated the lease, and when they said that, for example, in the force majeure clause, that even if there's something that is a force majeure, that the tenant would still be obligated to pay rent. And so the court, again, another quote that I wanted to point out, this is a crisis that has never occurred in most of our lifetimes, and that raised questions of fact. And so forth. So ultimately, the bottom line is you have here another case, this time out of New York, which rules preliminarily on the tenant's behalf and the tenant's favor. And so what do we have here? We have really a lot of mixed results. And that's not good for landlords, not good for tenants, because there's really a lack of certainty. You can't predict where some of these courts, these are different judges, analyzing similar fact patterns, similar lease clauses. Again, people can draw distinctions between each lease. Maybe the language is different, maybe a different jurisdiction, maybe it's a different type of user. Restaurants seem to be more, the judges seem to be more sympathetic for restaurant tenants, although again, this is an example of a cosmetic retailer where the judge was seemed to be leaning towards the tenant side. So we really have a mixed bag, mixed results, and it's very hard to predict. And it's still a guessing game. Nobody knows where we're going to ultimately end. But the past several cases that have come down in the past past few months have really given tenants a lot more leverage in their negotiation with landlords, and that there is some hope that tenants might prevail, at least for the very short period of time when COVID-19 required the tenants to shut down due to the government orders. That to me is the most relevant period of time. So if the government order required a tenant to shut down for 2 to 3 months, there is a strong argument that the tenant would not be obligated to pay rent during that period of time. That does not mean that the tenant can just get out of a 10-year lease, or that in all cases the tenant will be permitted to stop paying 100% of the rent, but at least there's some leverage here that the parties should really come up with their own compromise and work out these issues outside of the courts, because again, it's really a guessing game right now as to where some of these cases are going to come out. Okay, well, that does it for this month. I hope we get some more clarity in the next few months. We'll probably cover this Boston case, which is a pretty significant case, again, on a tenant's favor next month, unless, again, we get some more cases that come down between now and then that are even more interesting. So until then, thank you very much. Bye-bye.